Hi, my name is Nick Mermiges. I'm a South Carolina family court attorney, which means I handle mostly divorce, custody cases, modifications, trials, and appeals. And today I'm just going to briefly explain, or hopefully briefly explain, how equitable division works in South Carolina courts. What is equitable division? Equitable division is where the court divides the assets and debts that were acquired during the marriage or that are marital in a fair way, in an equitable way. What are marital assets? What is marital property? Okay. People frequently think that it matters whose name certain assets and debts are in, and really, as long as it's one of the spouses, it really doesn't. Okay. Marital property is all property acquired during the marriage. Doesn't matter if it's solely in one spouse's name or the other. The court will divide marital property and marital debt, meaning all debt acquired during the marriage, and it will not divide non-marital property, which would be either property acquired before the marriage or property that falls into some exceptions like an inheritance or a gift, from like a family member. Those kind of things, even if it's during the marriage, that's non-marital property, meaning, that's not going to be divided or split by the court. Okay? Now, in most cases, even in hotly contested, high asset cases or cases where folks are very upset, the marital property and debt is usually divided 50-50, okay? In some instances, it could be 60-40 or 55-45, based on the contributions of one party or the fault of one party, but it's frequently just about evenly divided, okay? In complex cases and even in some simple cases, the real fight or the real thing that you need a lawyer to uncover and work towards is, one, identifying all the marital property, right? Making sure that you know about where all the investments and savings and retirement and even tangible property is and what it's worth. Knowing the marital property, knowing the marital debt, okay? Knowing that is very important, because if you can't identify what's there, you can't even have a fair division of it. And then beyond that, a big fight that happens is either including or excluding property based on claims that it is marital or it's non-marital, okay? And then there are also some other concepts like dissipation, where a spouse wrongly spends marital assets, whether it's like to pursue gambling or an addiction or an affair, where the court is going to be asked to account for that spouse's wasting of those assets, and basically to make the other spouse whole by giving them more than half of what's left. Okay? So in terms of marital versus non-marital, I already explained there's premarital property acquired before the marriage, inheritance, bequest, gift, things like that, whether before or during the marriage, you usually aren't entitled to. But there are some exceptions. So first, if you commingle non-marital property with marital property, like you dump it all in the same account and then you transfer it over and you buy a home with it and you refinance it, if you use that money to the benefit of the marriage or put it into a marital piece of property, and you commingle it with marital funds like earnings from income or whatever else, the court can find that basically turns that otherwise non-marital property into marital property. If you can clearly trace what the premarital or non-marital property was spent on or exchanged for, you can arguably keep it as non-marital, but that becomes an issue to dispute or to fight about. Okay, what frequently happens in cases, there's a premarital home, okay, where one spouse owned the home and the other spouse comes in and moves with in with them, or piece of land or an investment property, whatever else. okay? Even if that property would normally be premarital, sometimes spouses will retitle it and put it in both spouses' names. If that happens, that's called transmutation. That changes that non-marital property into marital property, and the other spouse is entitled to usually get half of it or their fair share of it. So retitling, commingling, those are a couple of things that can change non-marital property into marital property. And I want to be very clear, marital property is very broad and encompasses just about anything you can acquire during the marriage. So for example, like a personal injury settlement, if the injury happens while you're married to that person, arguably and likely that's going to be part of the marital estate, meaning you're entitled to half of it, okay? Beyond, those, the commingling, the transmutation issues, another thing would be if you took a joint mortgage out on a premarital piece of property and the other spouse's credit was used and they were added to that note, okay? So you have a free and clear piece of land, you take out a mortgage, and both spouses' names are on that debt, okay? That could probably be enough to change the underlying asset into a marital asset from a premarital asset, okay? Likewise, there's a concept called special equity. So if you live in a premarital home and do a bunch of work on it, okay, which actually that happens, you put a deck in, you fix the driveway, you make an addition, okay, whether you do it with your own hands or you do it with marital funds, right? So you both make wages and you put a new wing onto this premarital home and it makes the value go up by $150,000 or something like that, okay? Under those circumstances, the spouse, even if it's premarital, the spouse who's, didn't own the property at the time of marriage, they'd probably be entitled to special equity. And what that usually means would be they're at least entitled to their fair share of the appreciated value, okay? Whatever changes increase the value of the property, they're probably entitled to recover, for that, okay? Similarly, okay, although it depends on the case, if you use marital funds to pay down, the note, the mortgage on a premarital piece of property, thereby increasing its value, you're probably entitled to your fair share of that equity reduction, okay? Because obviously marital funds are just income earned during the marriage. They're used towards this mortgage. Even if you're not the primary breadwinner, if it's a long marriage, I think that you have a credible claim to that property, okay? And, in other cases, things can get very complicated. People can try to, falsely put their property in their family members' names or business partners' names. And, if that happens, you can add those people as parties to the litigation to have the court basically command them to disgorge that property, okay? But those are in more complex cases and relatively rare, okay? In a normal case with salaried folks, the main issues with premarital property relate to retitling. They relate to potentially transmutation or to special equity. And if someone's behaved badly, to, spent money on an affair, gambling, to dissipation, making the estate whole for that and adjusting the split accordingly. Okay, and likewise, the same would be true for marital debt. All marital debt acquired during the marriage is going to be divided. It's going to be part of the equitable division. There are some rare exceptions to that. Again, one would be debt that's acquired for a bad purpose, gambling debt, taking a paramour on a vacation or something like that. That's not going to be split 50-50, okay? And when we say split 50-50, what I really mean is the court looks at the assets and debts and assigns assets and debts to each side in a way that's fair. And it's usually close to a 50-50 split. So it doesn't automatically mean that you're just going to get half the other person's debt. It just means that's going to be considered and allocated, okay? So most marital debts, most debts acquired during the marriage are going to be divided equitably so that there's hopefully going to be an outcome that, the court is going to seek an outcome that's close to 50-50, okay? Besides sort of the bad behavior exceptions, in my experience, usually student loan debt used to pursue a career That's usually not allocated one way or the other, just because obviously the debt was incurred to give someone a credential or a degree. That debt usually follows the spouse who took out that loan. Okay, now, in normal cases, there's still issues about fair divisions of property because all these assets have debts attached to them, and how are we going to untangle these people's financial affairs? Because obviously you're getting a divorce from somebody, and you're not communicating with them well, and the goal here is to, as much as possible, untangle your finances so you don't have to deal with this person and negotiate and fight about who's going to pay what. Okay, and so the court's going to make a final decision for you, or you can negotiate an agreement. And I want to be clear that most agreements, if the parties agree on a different kind of split, okay, court will almost always approve it unless it's really an unfair deal, on its face. Because, so for example, if somebody has a claim for alimony, but they'd rather just get a lump sum of money ahead of time on the front end and will waive that claim for alimony, that can be a part of a negotiation. So they could get 70% of whatever liquid assets there are instead of, and waive their claim for alimony in exchange for that. And a court would probably approve of that. Okay. But when it comes to these assets, debts are attached to most of them. So you may have a home and it may have some equity, but there's also a mortgage, right? And so whether the parties negotiate it, at mediation, or the judge makes a decision, something's got to happen, okay? Because usually those mortgages are in both people's names. And while the court can, and the court can order that the home be sold and the mortgage paid off, and then if there's any proceeds to have those split, or the court can award one spouse or the other spouse the home if they want it, okay? But if that happens, the spouse who's awarded the home also has to pay the mortgage. And so and the court can order them to pay it and say, you've got to make these timely monthly payments, but the court can't order a bank not to, take a collections action against you and ruin your credit score if your ex-spouse fails to make their mortgage payments, okay? So, even though the court can order them to do it, if they don't do it, you're still going to get hurt, okay? Your credit score is going to get hurt, or there could be collections action against you. And so basically, you need to have, the court usually orders, that the home be sold they order that the spouse taking the home get it out of the other spouse's name, usually within 6 to 12 months after the case is over. That's in a contested case, okay? And then they usually also, as a safety precaution to some degree, include that if they can't get it out of the person's name, that the home be immediately placed up for sale after that time window. And so that should, theoretically pay off most of that debt. And so basically when you're negotiating, or you have an attorney negotiating these issues, you want to make sure that your lawyer includes the kind of language that's going to protect you and give you some kind of remedy if the other person, steps out or doesn't follow the court order. Okay, and sometimes you have to go in and enforce the court order, and that's what's known as contempt of court. And you can bring someone in on contempt of court, and if they're willfully in contempt of court, they'll be punished. All right, but the point is that your divorce agreement has to be written in a way that it's clearly enforceable, that protects you as much as possible, so that your future risks that you may not have thought of are reduced as much as possible. So if someone gets an asset, and there's debt tied to it, you need to make sure that that you've got as much protection as possible. Okay, and the same is true for other big purchases like vehicles that have car notes on them and boats and things like that. Okay, and it's not just if there's a car note that on the $30,000 car note and a $35,000 vehicle, and one person's going to take it over, you also need a requirement that they carry insurance. Because if they crash it, and it becomes totaled and worthless, and there's still this joint debt and they don't pay it, you could be on the hook for that, okay? So, when you untangle finances with someone, when you co-sign on a loan with someone, there's a certain amount of risk that you're always going to take on. That's just the way that it works. And when you're getting divorced, a divorce attorney can't eliminate all that risk, okay? But having a competent lawyer during that equitable division process who can think about those risks, they can really mitigate that risk and make sure that if someone, does something wrong, that there's a relatively quick remedy, right? So as I said, the whole point is getting a fair outcome, whether it's a negotiated outcome or one you have to fight for because the other party's not being reasonable, in a way that unwinds the parties' finances with one another and gives you your fair share of the marital estate and accounts for, all these outside factors and contributions to the marriage. Okay, so that's generally how equitable division in South Carolina works. The assets and debts are considered, they're allocated to each party, and they're split relatively evenly. Okay, and then there are all these other things that are considered that aren't addressed in this video in terms of child support if they're kids, spousal support, attorney's fees if you have to, if you're proving somebody's committed adultery or if one spouse has a lot more money than the other, and other specific requirements about how you're going to get rid of these joint debts and assets. So I hope that gives you a sense of how in divorce cases equitable division or the division of assets and debts takes place. There are obviously a lot of more complicated cases that our firm has handled, but having the experience with complicated cases gives us sort of the wisdom to handle your simple case in an efficient and effective way. Okay, so obviously we'd be happy to speak with you if you're going through a divorce in South Carolina. We're located in downtown Columbia. We take cases statewide. You can call 803-724-1258 for a free telephone consultation, and we'd be happy to help you. Thank you very much.